We are crossing over back to the Milimani Law Court for the judgment of the murdered Sharon Otieno, the former Rongo student who was murdered in 2018. Former Governor Okoth Obado and two others have had to answer to murder charges. Let's hear the judgment.
Deceased death was not caused by natural causes, and it was not as a result of an accident or inadvertence. I do not therefore have any hesitation in finding that Sharon's death was unlawful. The singular question now left for my determination is whether the accused persons, with malice aforethought, participated in the unlawful killing of the late Sharon. As correctly submitted by a learned counsel representing each of the accused persons, the prosecution's case in this case is solely based on circumstantial evidence. This is so because none of the 42 witnesses who testified in support of the prosecution case gave direct evidence regarding how the deceased met her untimely death. None of them claimed to have witnessed the unlawful killing of Sharon. This being the case, I think it is important to understand what circumstantial evidence entails and the threshold set by the law for it to sustain a safe conviction. Circumstantial evidence is evidence of surrounding facts and circumstances from which the existence of a fact in issue may reasonably be inferred. It does not directly establish the fact to be proved, but it leads to its proof through a process of logical inference. The Evidence Act, Chapter 40, Chapter 80 of the Laws of Kenya does not distinguish between direct and circumstantial evidence with respect to admissibility. Both types of evidence are competent and may sustain a conviction if they meet the threshold of proof beyond reasonable doubt. The Supreme Court of Kenya in Republic versus Ahmed Abdul Fathi Mohammed and another comprehensively unpacked what constituted circumstantial evidence and its application. I have reproduced some extract from this evidence, which is a long quote, which I think I need not read in the interest of time. It is settled law that for circumstantial evidence to sustain a conviction, it must consist of credible and cogent evidence, which irresistibly pointed to the conclusion that the accused person and nobody else committed the offense charged. The circumstances should be firmly established in a way that they formed a chain so complete that they were incapable of any other hypothesis other than the guilt of the accused person as charged. The above legal position was also succinctly articulated by the Court of Appeal in the case of Save versus Republic, and the court expressed itself as follows, and I quote, "In order to justify a conviction on circumstantial evidence, the inference of guilt The inculpatory facts must be incompatible with the innocence of the accused and incapable of explanation upon any other reasonable hypothesis than that of his guilt. There must be no other coexisting circumstance weakening the chain of circumstances relied upon. The burden of proving facts that justify the drawing of this inference from the facts to the exclusion of any other reasonable hypothesis of innocence remain with the prosecution. It is a burden which never shifts to the party accused. In denying the offense, each accused person denied having played any role in planning or causing the death of the late Sharon. The first accused, as noted earlier, maintained that he had no motive or reason to cause the death of Sharon, which was demonstrated by the fact that even after terminating his relationship with her, he continued providing her with financial support to ensure her upkeep and general well-being, including her pregnancy to the very end. And according to the first accused, a further demonstration that he had no motive to end the life of Sharon was that his intimate relationship with her was at the time an open secret, as it was within the knowledge of members of his family, and it was already in the public domain. The second accused, on the other hand, also asserted that the only role he played in matters concerning Sharon was the role of a messenger to convey money and other communication from the first accused to ensure her welfare. That for this reason, he did not also have any motive to kill her. On his part, the third accused claimed that he barely knew Sharon, as he had only met her once, and he therefore did not have any reason to be involved in her death. In view of the assertions made by the accused persons regarding lack of motive to kill the late Sharon, I find it necessary at this juncture to address the issue of motive and its place in criminal responsibility. Motive, simply put, is the reason for committing an offense. It is provided for under Section 9(3) of the Penal Code as follows. Unless otherwise, and I quote, unless otherwise expressly declared, the motive by which a person is induced to do or to omit to do an act or to form an intention is immaterial so far as regards criminal responsibility. When discussing motive, the Court of Appeal in Limabula v. Republic noted that proof of motive is not essential to prove a crime, but may be relevant, particularly in cases resting on circumstantial evidence. With specific reference to the offense of murder, the same court also held in Robert Onchiri Ogeto versus Republic, that proof of motive was not essential to prove malice aforethought. The court held that the prosecution, and the court held, and I quote, the prosecution does not have to prove the motive for commission of any crime, neither is evidence of motive sufficient by itself to prove the commission of a crime by the person who possesses the motive. By virtue of Section 206A of the Penal Code, malice aforethought is deemed to be established by evidence showing an intention to cause death or to do grievous harm. It can be reasonably inferred that when the appellant, now referring to the context in which this case was decided, when the appellant stabbed the deceased with a knife on the chest, he intended to cause death or grievous harm to the deceased. And for that being the case, the court was satisfied that the appellant was properly convicted for the offense of murder, even though motive had not been proved. Regarding the doctrine of common intention, which is the centerpiece or lies at the heart of the prosecution's case, the doctrine is codified in our law under Section 21 of the Penal Code, which provides that when two or more persons form a common intention to prosecute an unlawful purpose in conjunction with another one, in conjunction with one another, and in the prosecution of such purpose, an offense is committed of such a nature that its commission was a probable consequence of the prosecution of that purpose, each of them is deemed to have committed the offense. In Joroge versus Republic, the Court of Appeal confirmed that the applicability of this doctrine does not require proof of an express agreement. It may be inferred from conduct, presence, and participation of the accused persons before, during, and after commission of a crime. The level of participation, even though minimal, or the role played by each offender, even though insignificant, attracted full criminal responsibility if done in furtherance of the common criminal intention. The above principle, read together with the definition of principal offenders set out in Section 20 of the Penal Code, ensures that criminal liability attached equally to all those who contributed to a joint criminal enterprise. Section 20 of the Penal Code provides that criminal liability applies equally to all persons who actually commit the act constituting the offense, and to persons who aids or abets another person in committing the offense, or procures another person to commit an offense. This category of persons are the persons who the law recognizes to be principal offenders. In this case, the first accused admitted the prosecution's claim that he had an intimate sexual relationship with Sharon, as a result of which she became pregnant for him. Although I wholly concur with the first accused's submission that impregnating a consenting young lady of age was not a criminal offense, it is clear from the totality of the evidence adduced in this case that this particular pregnancy formed the basis of subsequent events which culminated into the unlawful death of the deceased. My thorough analysis of the evidence adduced by both the prosecution and the defense shows that the first accused claim that he had accepted the deceased's pregnancy or that he was comfortable with it, which in his view was demonstrated by the fact that he had continued to give her financial support for her upkeep and to nurture her pregnancy, even though he had terminated their relationship, was, in my considered opinion, actually not sincere and was not true. I make this finding because there is evidence from PW9 and PW30, Sharon's mother, which evidence was not expressly challenged by the first accused. That the first accused had actually exerted pressure on Sharon to abort the pregnancy and had proceeded to give her 30,000 for that purpose, which pressure Sharon refused to succumb to, following advice from her mother. Granted, it may be true that part of the reasons that the first accused decided to terminate his relationship with Sharon was his discovery that she had allegedly lied to him about having a business in her family life. But on the first accused's own admission, he learned about Sharon's pregnancy in March of 2018. And this is the same time he claims to have terminated or decided to terminate his relationship with the late Sharon. In his admission also, and from the account given by PW28 and also PW30, who is Sharon's mother. From that time, the first accused confirms that he became evasive and withdrew his financial support. And according from the account given by PW28, it is apparent that the first accused actually withdrew, withdrew, but did not reduce the financial support he used to give to Sharon, considering that according to PW28, the Sharon was reduced to asking him for assistance for money for her needs. And she was also forced to seek his intervention in identifying a journalist to make her plight public. If indeed the first accused was the magnanimous, considerate, responsible, and caring man he presented himself to be, and he genuinely intended to give Sharon both financial and material support throughout her pregnancy, as he alleged, my take is that he would not have distanced himself refused to pick up her calls and withdrew his support from March until July of 2018, when PW1 appeared at the scene with imminent threats of publishing his illicit affair in the mainstream media. It cannot be mere coincidence that the first accused suddenly developed interest in the deceased's well-being and that of her unborn child when Sharon's decision to cause publication of their illicit relationship in the print media was communicated to him by PW9 in the presence of PW28. The first accused was emphatic in his defense that he was not at all concerned about the deceased's threat to publicize their love affair in public, because in any event, it was an open secret, as it was already in the public domain and members of his family knew about it. And although it may be true that members of his family and some members of staff of the Migori County government knew about the affair, as claimed by PW42, the investigating officer, it cannot be entirely true that all members of the public in the country who held the first accused in high esteem as the political head of the county government of Migori actually knew about it. For instance, PW28, who was a resident of Homa Bay, did not know about this relationship until Sharon herself told him about it. There is also evidence that even though claiming that his relationship with Sharon was already in the public domain, the first accused clearly wanted to contain it within the scope it had reached and prevent it from further spreading to contain it in the scope within which it was, because to illustrate this point, I would refer to the evidence of PW9 relating to what the first accused told him when he was leaving his Rapogi home after the meeting. And this is what PW9 claims that the first accused told him, and I quote, "The governor then escorted us outside the main house. We stood at the staircase. He bade us goodbye and promised to keep in touch after instructing me not to tell anybody about Sharon's pregnancy." This particular aspect of PW9's testimony was not expressly challenged by the first accused. Further, when under cross-examination by counsel for the victim's family, PW28, who the first accused admitted was a truthful witness, recalled having stated in his witness statement that when in a meeting with the second accused outside Tausi Hotel, the second accused had asked him how they could get access to the deceased's and PW1's handsets, since they contained evidence that could take the governor to the media. The second accused was not involved in the information in the handsets, as reviewed by the evidence adduced in this case. And the concern he raised about this information getting to the media must have emanated from the first accused. From the above evidence and considering the exorbitant demands that the late Sharon had made to the first accused as a precondition to withholding her intention of going to the media with her story, I am persuaded to agree with the prosecution's submissions that the various amounts of money conveyed from the first accused to the deceased, either through PW28 or the second accused, were not genuinely intended to promote her well-being, but were designed to contain, to manage, and to delay or to make Sharon abandon her intention to publicize her affair with the first accused as a scheme to eliminate her and to silence PW9 was being devised. The same argument applies to the first accused's promise to buy a plot and construct a 3-bedroomed house for Sharon in Homa Bay, since the promise was yet to be fulfilled by the time she met her untimely death. From the totality of the evidence adduced in this case, it is my considered view that the first accused had a very strong motive to unlawfully end Sharon's life, to ensure that his illicit affair with her was not widely publicized through the print media, in order to save himself from possible public embarrassment and reputational harm, and to safeguard his political standing. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot. Sorry, let me go read this again. There is no doubt that the first accused would have been the ultimate beneficiary of such a plot, as he was likely to suffer if the deceased actualized her threat of publishing them in the media, her story regarding their illicit love affair. In the premises, I am persuaded to agree. I'm persuaded to agree that in order to eradicate the imminent threat of having the possibility of having his name or reputation dragged through the mud by publication in the mainstream media of this relationship with Sharon, the first accused instigated a scheme to eliminate Sharon and using his influence as the governor of Migori County, he enlisted the services of his trusted aides, the second accused, who was his personal assistant, and the third accused, who worked as a clerical officer in the county government of Migori. This must be why, in my view, the first accused insisted to PW9 and to PW28 that all matters concerning Sharon's pregnancy should be directed to the second accused. And he consistently used the second accused as his intermediary with Sharon, PW9 and PW28. From the evidence, it is clear that the second accused embraced the role he had been assigned by the first accused. Because besides delivering money and other messages to Sharon, and sometimes to PW 28 on behalf of the first accused. He also warned or instructed PW 9 and PW 28 to keep off all matters related to Sharon, as he would henceforth deal with them. This finding is also strengthened by the evidence also adduced by the prosecution, which demonstrate or which shows that accused number 2 also embarked on activities meant to disguise or conceal his communication with Sharon, PW 9 and PW 22, as well as M-Pesa transactions. And this happened prior to the commission of the offense. This evidence is demonstrated by the evidence, which was also admitted by the second accused, that on the 23rd of August 2018, he planned a visit to Nairobi by PW 9, PW 28 and Sharon, promising to schedule a meeting with the first accused. The first accused, as the evidence shows, was at the time attending a Council of Governors meeting in Nairobi. To facilitate the meeting, the second accused sent to PW 9 22,000 to finance their travel with Sharon to Nairobi. But in doing so, he did not use his M-Pesa account. Instead, he chose to use the Safaricom line of PW4 to send the money, allegedly because he did not have his identity card at the time, which was required to effect the transaction. However, the reason given by the second accused for failure to use his M-Pesa account to make this transaction was disputed or refuted by PW4, who claimed that the reason given by the customer who requested her to use her M-Pesa line to send this money, who turned out to be the second accused, was because the customer claimed that he did not have a Safaricom line. This juxtaposed with the second accused's evidence that he actually had an active Safaricom line goes to prove that in using this in using PW4's Safaricom line, the second accused was motivated by an intention of concealing his identity, which only means that he had a reason for wanting to have his identity concealed so that this transaction would not be linked to him in the event that there were some investigations that concerned the transaction or that concerned whatever schemes that were motivating this kind of dealing. I make this finding because I have no reason to doubt the evidence of PW4 because in my view, she was a completely independent witness as she did not know the second accused, and she did not therefore have any reason to give false evidence against him. So it is therefore my finding that the only reason that the second accused would want to conceal his identity was to avoid being linked to the Nairobi visit because it must have been planned for an illegal purpose. Another strand of circumstantial evidence adduced by the prosecution is that on the 27th of August 2018, the second accused acquired an Airtel line number 0739473321, which, in my view, was also aimed at disguising his communication with Sharon, PW1 and 28, and concealing his identity.